Imagine if you can make more money, get your clients better results by using the presumption of abuse. Here with Luke Homen. Luke, how you doing?
Doing great. Thanks for having me back, Bill.
Luke, thanks for sharing this idea of, we all want to make more money. We all want to give better results to the client.
Yeah.
But give us this nuance of presumption of abuse as a bankruptcy attorney.
Yeah. So let me give you the backstory. So there are always certain clients that don't really qualify for Chapter 7. They've failed the means test, but when you put them in Chapter 13, they're going to fail. Maybe they make 6 payments or 8 payments, but there's certain kinds of clients, and you just got that gut feeling and you've got that experience that's really informing your gut decision that that Chapter 13 is really not the right fit. So I had a client, and, always starts with the client, and she was working 80 hours a week. She was working at one of those residential homes for special needs kids. Her coworker had quit. So she's working 80 hours a week, but she's being garnished. But with all that overtime, she's way over all of our thresholds. But it was all just going to the creditor. It wasn't going to her pocket because they were garnishing 25%. So she knew she was going to quit her job unless they found someone else to help her so she could work 40-hour weeks. We needed to file a bankruptcy. This is not a long-term 13, but it's also, she's not fitting in a 7 because she's working 40 hours of overtime each week. So how do we fix that into legal analysis? All right. When you do the means test, there is a box number 40, and on it, this I've always viewed as like the box of death, right? This is, you have failed the means test, and it says, the line 39D is more than 17,150. In italics, there is a presumption of abuse. All right. So now reading this as somebody practicing bankruptcy, this is scary, right? You do not want to be in your heart an abuser, right? I mean, I don't. And so I always check that box. If I check that box, it'd be like the box of death. I never wanted to do it. And so instead you'd be like, man, I'm sorry, you're just a 13 and I don't know, try it. But they're just going to fail. And so then you talk to some of these clients, you're like, I tell you what, if there was a miracle that I could work and get you into a Chapter 7, would you pay me a higher attorney fee? And of course, the answer is absolutely yes. For my situation, I don't want to be in a 13. Get me in a 7, and I'll certainly pay you $500 more, $1,000 more. And of course, you disclose all that to your U.S. trustee. But I wanted to start exploring, what does that box mean? And so it's all governed by statute, which is great because it means it's going to be the same across the country. And let me just kind of read you some statutory language here. 11 U.S.C. section 704B2 outlines the statutory duties of the U.S. trustee or bankruptcy administrator after they review the debtor's initial financial documents. So once the U.S. trustee or the debtor independently indicates that there's a presumption of abuse, the U.S. trustee has to file a motion to dismiss or convert, or file a statement of reasons why a conversion is not appropriate. Okay, so mechanically how this works in cases is if you file this as a presumption of abuse, for me, it's either the paralegal or it's the auditor at the U.S. trustee's office is going to immediately reach out to me and ask for information. And the client's probably going to have to testify at the 341 on what we're putting in here. But what's the worst case scenario? The worst case scenario is that the U.S. trustee files a motion that gives you an option to convert into Chapter 13. So if you try this and fail, you're no worse off than just filing a 13 to begin with. But you have a potential, if you can pull this off, to successfully stay in a Chapter 7. Because what's happening here is it's not a declaration of abuse. It's not you are an abuser. It's a presumption. And in lawyer land, presumption just means we can rebut that presumption with evidence, and now all of a sudden it's not an abuse case anymore. And we've got another statute that tells us exactly what needs to be submitted. So it says, in any proceeding brought under this subsection, the presumption of abuse may be rebutted by demonstrating special circumstances, such as a serious medical condition, a call or order to active duty in the armed forces, or to justify additional expenses or adjustments to your income for which there is no reasonable alternative. So we now have 4 things that we can explore with our client when the means test fails us. First, you try the means test. But if at the end of the day on the means test, it's not telling the full story, we need to show why are expenses going to change? Why is income going to change? Do you have a serious medical condition? Or, never happened to my client, but called up to active duty.
Mhm.
So going back to our means test form, there's a spot for this. Under Part 4 on the means test, question 43, it says, do you have any special circumstances which justify those additional expenses or adjustments? And it even cites the statute for us. And then we've got some little tiny boxes. So as a practical matter, you can only type like 20 characters in there. And then you've got a number value. So what you want to do is get all your documentation because you're going to need it. It says in the statute you have to be able to document this. Type some little things in that box. Things that I've used in the past. Cancer. Somebody who we know is getting government furloughed. I've done that. I had a guy who just got a letter about mandatory retirement. We filed him even before the retirement because we could prove that that change in income was about to happen. We've done that lady who was working 80 hours a week. Other things I've done with expenses, though. I've had rural clients with crazy rural expenses, like they got to have their septic tank pumped or, rural stuff that's not in the means test. And if you can show those bills, he had to have a gravel road re-graveled or something. But those are all documentable expenses. Another one that's actually pretty common. Your client is driving a clunker that's fully paid off, but that clunker is not going to last very long. And so you need to go and have them get a used car. Well, pre-filing, they're either not going to qualify for a car loan or they're going to get taken advantage of. But post-filing, you could probably get them in a nice vehicle, but post-filing doesn't fit on your means test because that's pre-filing. So what I've done there is I've said, debtor needs to get a new car. Average used car price per month in Oklahoma is X, like $580 a month or something. And then put that $580 in there. Because what you're going to do is you're going to compare what you can document as reductions from your income, look back at that earlier section. And again, the auditor is going to be looking at this. There's going to be extra legal work involved. So you're going to be earning that extra fee. But I could tell you, let's see. So we file about 400 cases a year. We probably file about 15 as presumption of abuse. I only file them when I can prove them. So they've all been successful. And that's about 5% of my cases. And you charge some extra money on each one of those. Now you don't have failed 13s. You've got 7s with happy clients that you could charge more money. You can make more money. You can get better results. And you could do some interesting legal work.
Now, what
Go ahead.
percentage of these attorneys are even thinking like this? Because this is
Okay, so I read a lot of bankruptcy petitions. For what it's worth, if you know that there's an attorney in your district who's a really good attorney, it's worth the $3. Just go download some of their petitions. You'll find some good stuff in there. But I read a lot of bankruptcy petitions. I'd say there's only 1 or 2 other attorneys in my state that even file these. I'd never even heard of someone trying to do this until I just had a case where I was like, I'm going to try this. So I think it's super uncommon. I'd never heard of it. And I found 2 other guys who do it.
When you say you charge more, how much more do you charge?
It depends on how slam dunk the case is, how much evidence I'm going to need to present. I would say a range of like $200 to $750 more.
Okay.
And again, we're going to disclose that on our disclosure fee compensation. So we've done nothing wrong in the eyes of the U.S. trustee because it's all disclosed. If it's a slam dunk case, like my guy has terminal cancer, you don't need to charge very much because all you do is produce a piece of paper showing he's got terminal cancer and you've passed the statute. But then sometimes you've got cases where, I don't know, I got to produce gravel receipts and a whole bunch of other stuff. And maybe that guy charged $700 more.
Yeah.
But this is real value for both you, the attorney, and the debtor.
The whole conversation around failed 13s keeps a lot of people up.
Yeah, because
And if we get to
one of the things that's going to change your practice is if you stop filing bad 13s, you're going to stop burning so much of your time because it's not that you don't have a client that, wants to succeed. It's that Chapter 13s for people who are working overtime or who have medical issues or who have documentable other expenses are just so much more likely to fail.
Yeah. Yeah. Wow. Luke, this is very, very valuable. I mean, we're going to have all the stats, the statute numbers, all that stuff in the description below, but this is hugely valuable. We're always looking for ways to bring value to the debtor attorney that's sort of like outside the box. This qualifies. Luke, anything else on this? I wish I could ask you more questions. Not being a lawyer, I
Yeah.
can't get in the weeds.
Here's how I describe it to my clients. For the most part, bankruptcy is math, right? It's lawyering with numbers. And there's a certain time, though, when math fails you. It doesn't tell the whole story. And sometimes as an attorney, you need to hop into the courtroom or, on the phone with the U.S. trustee, and you need to do some actual lawyering. You need to do some storytelling.
Yeah.
And that's really what this is about. It's about saying, my client doesn't fit squarely into the means test boxes, but they still deserve bankruptcy relief. And this person is not an abuser.
And it makes
And
sense.
if you can document these things and your client can testify to them, the statute says you're going to succeed. And you might as well try it, because the worst case scenario is they give you the option to move you into a 13 and you're no worse off than you were before.
Right. Right. Wow. Luke, thank you for thinking outside the box. Thanks for what you do for the debtor bar.
That's what I try to do. It makes it more interesting.
Little by little. Thanks, Luke. Thanks for being on the show.
Oh, absolutely.